Amendment 242, originally put forward by my noble friend Lord Young of Cookham, seeks to secure parity between qualifying and non-qualifying leaseholders under the Building Safety Act 2022, extending the protection to 3 properties for all types of leaseholder. It would also amend the Building Safety Act to exclude shares in a property of 50% or less from being counted as wholly owned. My Lords, the Government can't accept Amendment 242 for a number of reasons. Firstly, we don't believe it would have the intended effect, and it may in fact undermine the protections currently in place. The noble Earl Lord Lytton raised concerns with it at report because of this, and he pointed out, and this is at Hansard the 18th of September, column 1239, that under my noble friend's amendment, post-remediation qualified status would disappear, and therefore if some further defect were to be found at a later date, the building owner would impose the cost of sorting it out on all the leaseholders, which is not, I'm sure, what my noble friend intends. Lord Lytton also observed that the amendment doesn't deal with minority shared ownerships. Secondly, I can only repeat what I said to my noble friend at report stage, which is that the range of issues which the amendment attempts to deal with is extraordinarily complex, so much so that they require rather more time for our lawyers, and indeed lawyers externally, to address fully. As will be clear from our amendments 288A to 288D in lieu of Amendment 243, this is a complex area of law, and with the greatest respect to your lordships, Amendment 242 does not deal comprehensively with the difficult and overlapping pieces of legislation in this space. As my noble friend Baroness Scott and I have made clear in this House, the Government is looking at these issues carefully, but they're not straightforward, and the potential for rushed change to have unintended consequences is high. And I would therefore ask your lordships not to insist on Amendment 242. My Lords, as my honourable friend the Housing Minister explained in the other place last week, the Government accepts the principle of Amendment 243, originally put forward by my noble friend Lord Young of Cookham. We've therefore proposed Amendments 288A to 288D in lieu of Amendments 243 and 288. And this will ensure that the statutory protections for leaseholders continue where qualifying leases are extended, varied or replaced by an entirely new lease. And this amendment will be retrospective, so it will apply to qualifying leases extended, varied or replaced since the 14th of February 2022. And this means that those qualifying leaseholders who have, for example, extended their leases or are in the middle of the process will be covered by the protections.
Nevertheless, it is regrettable that he's not yet seen his way to accept the sensible and reasonable amendment that the noble lords here sent back to the Commons at report stage. And its purpose was to safeguard the rigorous safeguards which themselves were built into the Building Safety Act 2002, which this House was united in supporting, and which was designed to establish a robust regulatory regime that would ensure there was never another Grenfell Tower disaster. And less than 12 months later, and before the new regulatory regime even comes fully into force, the Government is giving itself and its successors sweeping powers to rip it up, save only for a very flimsy affirmative motion on a statutory instrument as a defence. And the modest amendment that your Lordship sent to the Commons simply required the Government to accept that if it wanted to change the fundamental structure and the mechanics of delivery of that building safety regime, it must be justified to Parliament and approved by Parliament. Now, the Government's response, and the noble Earl has just repeated it, is that it doesn't want to change the fundamental structure and the delivery of the building safety regime. All they want to do is take it away from the Health and Safety Executive, lock, stock and barrel, with no changes at all, except in the nameplate and the branding. And if that is true, the amendment before your Lordships today is exactly in line with their intentions. Amendment X1 picks up the point that the noble Earl made about our original amendment to the Commons, that it might have been flawed because the wording would obstruct the transfer of the statutory committees from the HSE to the new, completely unspecified and unknown safety regulator. And the revised wording in X1 therefore makes it quite clear on the face of the bill that it will be lawful to make that transfer. And this amendment is simply designed to avoid changes in how the new regulator is structured and organised, and to prevent changes to the tasks which are entrusted to it and the statutory committees that underpin its work. And the amendment, if passed, will ensure that the government's replacement regulator still retain those duties and timescales, for instance, to review the regulations relating to electrical fire safety, the safety of staircases and ramps, safe escape routes for people with mobility issues, and fire suppression systems such as sprinklers. Now, there's other detail, but in the interest of time, I will simply say that the original arrangement in the Building Safety Act was that those committees and tasks could only be changed by the Secretary of State if he or she received a proposal from the regulator themselves to put into place. And that was because it was seen as very important that the regulatory regime should never again be captured, as it had been in the past, by departments and ministers taking short-term political decisions. And the regulator would always be able to independently assess what the needs are as far as improving safety goes, and then make recommendations in public to ministers for them to decide on action. Now, the Noble Earl has offered us a very sincere undertaking that, at least for the time being, nothing will change, and that ministers will not be tempted to steer away from making essential safety improvements that they deem politically difficult or a bit too costly, and that they will faithfully press ahead without delay when those fire safety reports come in, however revealing and unwelcome they prove to be. And, of course, the Noble Earl is absolutely sincere, but I would say to him, ministers and secretaries of state come and go, and the sincerest of undertakings can be withdrawn when the facts are said to have changed, and the accountability given by an affirmative resolution is tenuous. And I urge the Noble Earl, the Minister, today to retain the progress that was made during the enactment of the Building Safety Act by safeguarding those statutory committees, reinforcing the obligation for those long-awaited safety studies, and making sure that the 3-year timescale is retained. And the way to do that is for him to say that, on mature consideration, he will accept Amendment X1. I beg to move.
ZC1 in my name. And can I begin by paying a heartfelt tribute to my noble friend for the very real progress that has been made since we last discussed this matter in helping qualifying leaseholders who extended their lease after the Building Safety Act came into effect. My Lords, in a nutshell, the Building Safety Act extended protection to qualifying leaseholders against the costs of remediation. However, inadvertently, the legislation then said that if you renewed your lease after the Act came into effect, you lost that protection. The government recognised that there had indeed been a mistake, and at report stage, I moved Amendment, I think, 243, which would retrospectively have put the leaseholders who extended their lease back within the protection of the BSA. Now, at the time, before it went back to the other place, my noble friend resisted my amendment and said that the issues require very legal dissection and working through, and that is what we're doing. And when I summed up, I said this: in a nutshell, the government made a mistake when they drafted the Building Safety Act. Unwittingly, they have removed the protection that some leaseholders were entitled to. They have known for months that there has been this defect, and I do not accept that the defect is so complex that it cannot now be put right. That is what my amendment does, and I sought to test the opinion of the House. Now, I don't know what my noble friend said to the department when he got back, but what had previously been impossible to do within the context of this bill suddenly became possible. And I'm grateful to my noble friend for tabling amendments 288A, 288B, 288C and D, which in effect do what I asked the government to do last time. And I'm, as I said, grateful to my noble friend for the pressure which he put on the parliamentary draftsman to correct an injustice which had unwittingly been perpetrated. Now, against that background, it might seem churlish of me to have tabled Amendment ZC1, but there remains a problem in that leaseholders who extended their lease and therefore lost the protection of the BSA will have received invoices and bills for payment, and some may indeed have made payment. And the government amendments, as drafted, do not entitle those qualifying leaseholders to a refund. And what my amendment ZC1 does, and I'm grateful to the Public Bill Office for help in drafting, which I hope will inject a note of caution into any remarks that the amendments are imperfectly drafted. What my amendment seeks to do is to say that in those circumstances where a qualifying leaseholder has already paid the remediation costs, which they needn't have done, in those circumstances they are entitled to a refund. Now, under the government's amendment, there is a provision whereby the government has powers under regulations to make certain provisions. And what I want my noble friend to do is basically answer the question that was put twice in the other place. I refer to column 199, October the 17th, the speech by Mr. Pinnock, the opposition spokesman, on housing. We welcome the concession that has been made, albeit with one proviso. Ministers must take steps to ensure that leaseholders who paid service charges over the past 15 months in the belief that they were not eligible for the leaseholder protections under the Act because of the government's mistake are reimbursed. Those individuals should not suffer financially as a result of a drafting error which should not have been allowed to occur in the first place. If the Minister, I hope she is listening to this point, he said, can provide us with some reassurance on that point, we will happily accept the government's amendment in lieu. And my right honourable friend, the Leader of the House, Sir Peter Bottomley, also made the same point. Now, in winding up, Rachel Maclean, under tremendous time pressure because of the timetable motion in the other place, was not able to answer either of those two questions. So the question I want to put to my noble friend is if, as he implied, he is unable to accept my amendment, whether under the provisions of his amendment, which enables certain regulations to be laid, I think it's little 11, the provision that were made in regulation under the section includes a provision which amends the section, provision which has retrospective effect. Can my noble friend give me an assurance that if a leaseholder has paid the bill, and he needn't have done, that my noble friend will use the powers under his own amendment retrospectively to entitle that leaseholder to a refund? That is the import of my amendment, which I don't wish to press to a division, but I do hope in return my noble friend will be able to give me the assurance that he seeks. Now, finally, my noble friend's amendment ZC, or motion ZC, knocks out a whole range of amendments that were actually passed without a division in this House, which extended protection to non-qualifying leaseholders. And basically, these are leaseholders living in buildings under 11 metres, enfranchised leaseholders who are counted as freeholders when it comes to the Act, and also those who own more than 3 properties in buy-to-let investments. And there are real problems in the people under 11 metres. They get no protection at all. They can't get a mortgage. They can't sell. They have to pay the cost of remediation because that's the only way the building can get insured. And they face exactly the same problems as people in buildings over 11 metres, but they get no protection at all. Then we have the leaseholders who, following government advice, enfranchised and became freeholders. And despite assurances I was given by the then Minister that they would be treated as leaseholders, the bill actually treats them as freeholders and denies them the protection extended to leaseholders. And then the problem of those who have buy-to-let properties. A person who owns a £1 million property, as well as other properties overseas, is protected. But somebody who owns 3 properties worth £100,000 each gets no protection at all. People who jointly own a property with their husband are counted as wholly owning. And there are a whole range of outstanding issues from the Building Safety Act, which I understand can't be addressed in this bill. But again, I hope what my noble friend is able to say, that in the proposed Leasehold Reform Act, it will be open to the government to reopen these issues, these unresolved problems of the BSA, and that legislation will be proposed to address at least some of the issues which I have outlined, which I believe are remaining unsolved problems arising from the BSA. So, in conclusion, I thank my noble friend again for the efforts he made in response to my original amendment, I think 243, and I hope he can give me the assurances that I'm looking for those leaseholders who have paid bills that they needn't have paid.
My Lords, I have an interest, certainly in both of these, the two items we consider under this group. And just for the avoidance of doubt, I declare my involvement as a practising, although nearly completely retired chartered surveyor, and with a knowledge of the leasehold and construction sectors. The noble Lord Stunell, I think, deserves the full appreciation of the House in what I can only describe as a progressive defenestration of the fuzzy edges that have surrounded the question of the building safety regulator. And he's whittled it down to the last elements as to whether this is actually a proposal for a like-for-like transfer from one jurisdiction, if I can term departments in that sense, to another, or whether, as he had previously identified, there was in fact some other morphing process that was going on behind the scenes. And I supported him previously in this, and I support him again in his endeavours here, because this really boils down to the last element as to whether there is a change. Now, my Lords, one could be forgiven for suspending a certain amount of belief here, because if there is going to be the process of transferring a body from Health and Safety Executive to some other framework, known or unknown, then why would one run the risk of the delays, the disruption and everything else that would be involved with that, if it were not for the fact that there was some other factor involved? So I think that the noble Lord Stunell's Amendment X1 is actually a very significant litmus test of what is actually involved here. And I would encourage the noble Elder Minister to consider very carefully whether the government actually means what it says in terms of saying it's a like-for-like transfer from one authority to another, or whether in reality it conceals some other paradigm shift. And I think that's very important. I'll now turn to the amendment of the noble Lord Young of Cookham. And I firstly apologise for the fact that his noble colleague has had to use my comments from previous stage in this debate in order to try and tell him that his approach is no good, because, of course, my comments were made in the context of saying it has a technical deficiency, but it didn't in any way suggest, I was not intending to suggest in any way, that the direction of travel in which he was engaged was faulty or in any other way imbued with anything other than the highest principles. Of course, he and I share a great deal of what has happened here. I think, again, he is absolutely right in his amendment ZC1, and I was pleased that he referred, sort of obiter, as it were, to the problem with the exceptions, because what has happened here is there is a sort of drawbridge approach to the liability and scope of the Building Safety Act, and it's that which creates these cliff edge approaches to who is qualified, whether their funding qualifies them or excludes them, and so on and so forth. And this is what has been dogging everybody all the way along the line. In reality, this delineation of the protections under the Building Safety Act is pernicious, because they're protections that any government should be applying in response to a serious and systemic failure in the home building industry to deliver adequate quality in building safety terms, and may I say, presided over by nearly 40 years of ineffective regulatory control of building standards. And if I may expand a little here, the government's resistance to anything beyond this straitjacket of parameters relating to the scope of the leasehold protections seems to be governed by an entirely arbitrary approach, an unwillingness even to collect data, understand implications or assess risk. And I refer especially to those non-qualified leaseholders that the noble Lord referred to. And my aim in all this has been to approach the thing on a much broader spectrum. The noble lord who 18 months ago we shared an amendment in the Building Safety Act has, I think, felt obliged to whittle down ever more to try and get to something that he can achieve here. And I absolutely applaud his persistence in this. But I'm forced to suggest, in the absence of any risk assessment, any government response going forward may be coming to what may be coming down the road will be blindsided and ineffective. And so hearing or speaking no evil does not present evils from occurring, and in this case to hundreds of thousands of innocent lease payers, to market sectors, to valuation, to lending, regeneration of urban areas and new homes targets generally. And all of this I've said before, and I apologise for repeating it again. But the noble lord has been assiduous in case campaigning, and I think that I suspect that ZC1, I don't know how many leaseholders might be affected by this, but I suspect it's actually really quite a small cohort, and I think the government should accept this and not allow this exclusion process, this drawbridge approach, to cut them off. Of course, I've tried to address the whole thing on a much wider scope for no avail, which is why when my words are used as a reason for denying the noble lord the fruits of his endeavours, I have to bear in mind that I seem to have been assiduously ignored throughout all this, up until today, when my words are being used by the noble Earl the Minister to against his own backbencher, and there's something frankly, quizzical about that whole arrangement. So I do hope that the noble Earl the Minister will at least give some indication that the government is actually cognizant of the serious and ongoing and growing problems that are arising here, to finance, to a whole sector, to a very large number, hundreds of thousands of excluded leaseholders, and much, much more besides. Because if they don't recognise that, then I think we are in for very serious problems indeed.
My Lords, the very fact that these two issues remain on the Levelling Up Bill demonstrate that the Building Safety Act is sadly unfinished business. And although the matters will not be concluded today, I can be sure that they will be raised in future legislation in this House, because they do need to be resolved. And having said that, I do support what the noble Lord Young of Cookham has said about the non-qualifying leaseholders, because there's a large group. They are being neglected, and they deserve not to be neglected. And I do, of course, support the valiant efforts of my noble friend in getting getting the regulation appropriate to the need.
Can I first of all thank all noble lords who have contributed to the building safety parts of this bill, which have been complex, but all done in the interest of the leaseholders who are at the end of this process. The noble Lord Stunell, noble Lord Young have outlined very carefully the reasons for their amendments, and I do hope that the noble Earl the Minister will carefully consider these outstanding matters raised, because we are all mindful in your Lordship's House that, as I said, behind all these technicalities and complexities of the Building Safety Act and the attempts to right its deficiencies in this bill are a group of leaseholders, many of whom were first-time buyers or are first-time buyers, who have had the start of their home-owning journey completely blighted by the worry and concern of remediation, uncertainty over service charges, and they've been let down by errors in the original bill, which meant that the status of their leasehold determined what charges they would have to pay. The noble Earl reassures us that further review of these matters will be undertaken, and I hope that will be the case, and that further thought will be given, if there is to be no compensation to those who have already had significant costs, that the government will consider how that might be dealt with in future.
Like my noble friend, the government is concerned about leaseholders who've paid a significant service charge where they have lost the protections upon extending their leases. Those who have paid out remediation costs whilst outside the protections may be able to bring a claim for unjust enrichment. I should point out to your lordships that we're not aware of this issue being raised with us by any affected leaseholders, so this issue may well be theoretical in nature. My noble friend may contradict me on that. That said, if we do come across any cases where remediation charges have been paid and are not returned, the Building Safety Act contains a power to make secondary legislation that we believe enables us to provide a bespoke remedy to this issue. And if cases do come to light, we will consider carefully whether that is the right thing to do. I can assure my noble friend...
I'm very grateful to what my noble friend has just said, but will they first have to go through the process which he outlined a few minutes ago of claiming unlawful enrichment before the government introduces the provisions which he's announced, which I very much welcome? Or will the government use the provisions under Little 11 to give them the protection without first obliging them to go through a complex process of claiming unlawful enrichment?
Well, my lords, as I said, we will consider carefully what is the right thing to do. I have no briefing on whether it will be necessary for leaseholders to go through to make a claim either directly or through the courts. We will take a decision as to what is right in all the prevailing circumstances. I'm afraid I can't go further than that. I can assure my noble friend that we completely appreciate the point that he has raised. The government is looking into what we can do for leaseholders who have had to pay excessive service charges where they have lost the protections. But for the reasons I've set out, including the potential for unintended consequences, which I described in relation to Amendment 242, I would ask my noble friend not to press his Amendment 288E. On the other issues he raised, I can't, as he will understand, preempt the forthcoming gracious speech or what may be contained in it. It would be quite improper for me to do so. However, I can tell my noble friend that the issues to which he has drawn our attention will be carefully considered in the department that I am representing. Turning to the noble Lord Stunell's motion X1, I recognise his continued concern and repeat my earlier assurances that the government doesn't intend to interfere with these important committees. Section 12 of the Business Safety Act contains appropriate provision to change the statutory committees of the Building Safety Regulator as needed in the future, giving the government and the regulator the flexibility needed to adapt the role of the regulator and its statutory committees. We don't agree that it's appropriate or necessary to impose restrictions on the use of that section, and we're concerned that, as drafted, this restriction would cause confusion whilst potentially preventing the use of the powers in Section 12 of the Building Safety Act to make changes to the statutory committees of the regulator in the future. But I would just say to the noble lord, the government does not intend to use the power in any way imminently. We consider it necessary to create the ability to move the Building Safety Regulator to an existing or a new body in the future, but we would look at any options very carefully and consider the recommendations from the Grenfell Tower inquiry before confirming the best way forward. This doesn't affect the timeline for the Building Safety Regulator's important work. We expect the regime to be fully operational by April 2024. We are determined to support delivery of the programme to that timetable. The changes will make sure that we are ready and have the flexibility in place to respond quickly to the Grenfell Tower inquiry report when it is published, and that we can be radical and long-term in our thinking. But as he will know, I'm sure, the evidence heard through the Grenfell Tower inquiry has made it clear that government must develop an effective role as system steward for the built environment, and we have committed to doing so. And our approach to regulatory institutions is central to this. This may require longer-term reform, which could include consideration of building-related regulatory functions, simple relocation of the existing building safety regulator functions as created by the Building Safety Act to another existing or standalone body. My Lords, I would therefore ask the noble Lord not to press his motion X1.